Good morning or afternoon, as the case may be, wherever you sit. And welcome to today's webinar on our 2023 calendar related to supported decision-making and individuals with disabilities, offered by the National Association of State Head Injury Administrators. Thank you so much for joining us. I'm Maria Crowley, NASHIA's Director of Professional Development, and I'm going to serve as your moderator for today's session. Closed captioning is available for you if you want to enable that at the bottom of your viewing window. If you need any assistance for today's webinar, send me a chat through Zoom or go to Zoom's support site. Questions for our presenter can be added to the Q&A or to the chat, and we will, time allowing, address those questions at the end of the presentation. A little bit about our organization. We're a national organization that was created to assist state government in promoting partnerships and building systems to meet the needs of individuals with brain injury and their families. And one way we do that is through training. We would be happy for you to join our organization, as we are a membership organization and offer several categories and benefits. You can always contact us for more. And just know, for today's webinar, general certificates of attendance and social work CEs are available. You'll receive an email after today's webinar that has a link with a general feedback form. There'll also be a link in that email for your certificates of attendance. Members receive those free of charge, and you can contact me for your promo code for that. The certificate, the evaluation links, as well as the slides for today and the recording, will be on our site later for access. For viewers of the recording, please go to Trainings on Demand to find out information on how to obtain the certificate. Now then, I'd love to introduce you to today's session and to our presenter. Supported decision-making encourages individuals with disabilities to make their own decisions to whatever extent they can, provided that they have the support to do so. We're going to spend some time exploring the supported decision-making and the elements of challenges and solutions, and focus on supported decision-making and alternatives to guardianship and potential guardianship. With us today are two individuals. Stephen Elville with Elville and Associates works with individuals and families to provide a very unique attorney-client experience and peace of mind solutions to the challenges that they face with estate, asset protection, tax planning issues, disability, and long-term care planning. He has extensive experience in working with clients involved in crisis situations and wills, trusts, estate planning, taxes, powers of attorney, living wills, advanced medical directives, Medicaid issues of all kinds, and a number of other areas. He holds many awards of distinction in his field and is active in many arenas of law and committees and councils. Also with him today, I'd like to introduce Jeff Stouffer, who's the Community Relations Director for Elville and Associates, and they're both joining us. Welcome.
Thank you, Maria.
Thank you.
I'm going to pull my slides and let you pop yours on up there.
Thank you very much. And I'm going to get situated here. And Maria, you will let me know if we are good to go there. I'm just going to move my bar down just a little bit so I can continue my slideshow. And you should see my slideshow at this point.
Looks good.
All right. Thank you very much. And good afternoon, I should say, to all. And I thank you for the opportunity to present. I thank NASHIA for the opportunity to present and for the work that Jeff Stouffer did with Maria to make this possible. So today, it's my privilege to talk about a subject that I know has caused a lot of confusion and ambiguity and also excitement at the same time over the past few years. And today we're going to be talking about supported decision-making, and I'm going to share my experience with you so far in my journey. I'm going to be talking to you from a Maryland perspective because I am an attorney barred in Maryland, and Maryland has recent legislation on supported decision-making that we are still seeing play out. But I was fortunate enough to be a little bit of at least a witness to this process as it transpired in Maryland, with supported decision-making finally becoming law in Maryland, as it has in many other states. And Maria was just telling me it has become law just very recently in Alabama, where she's from. So we're very glad to hear all of that. And so I'll be talking from a Maryland perspective only as an example to you. And I hope that each one of you will examine your own state laws, as I'm sure you are and have. But if you haven't, I want you to take a close look at that and use my examples as something to really compare. So with all of that said, the last thing I will say, we have had a great privilege of working with the Maryland Brain Injury Association, the Brain Injury Association of Maryland, and Elville and Associates, and Jeff, as part of that organization. We are very committed to those families with dealing with brain injury. So we're very, very glad to be with you today. All right, well, we're going to start our discussion, and we're going to, we have a limited amount of time. So obviously, this information is really educational in nature, and I'm going to start with an overview. So we're going to talk about understanding supported decision-making and what it really is and what its purpose is. And as I mentioned, I'm going to use Maryland legislation that is just really recent as an example in my experience, and I want you to juxtapose that legislation with the legislation in your state or the proposed legislation, and it's not going to be exactly the same. There are differences, so we want to be aware of that. And we're going to talk about what the promise of SDM is, supported decision-making, in relation to brain injury and beyond. We're going to talk about what supported decision-making is not. I find that talking about it from an opposite or negative point of view is really a good and effective way of trying to translate or communicate what supported decision-making is, because it's a simple concept in one way, and it's hard to understand in another way. So what is it not? What is its relationship to powers of attorney, advance directives, and guardianship? How, number 5, how SDM actually works, and how can it benefit people living with disabilities, young or old, and specifically here today, those with brain injury. And we're actually going to get into the Maryland legislation because I want you to see what I feel is Maryland's effort to have an extremely broad, extremely aggressive SDM law, so much so that it's confusing to some people, parents and others. And then we'll talk about next steps. So let's talk about what supported decision-making is. Well, it's many things, and that's one of the challenges. But I'm going to try to make sense of it to you from my perspective. I see it as a tool where a person with disabilities can be empowered and supported in the process of making their own decisions to whatever extent possible. So Maria talked about earlier in the introduction, something that I have been using as my own mantra about supported decision-making, which in my view is a person can make their own decisions to whatever extent possible through supported decision-making, providing that they have the support to do so. So that kind of is a very broad statement because it implies that we as human beings, we as a society are going to make the effort to provide that support so that others can reach their potential as far as their own capacity, their ability to exercise capacity. So that's what I think in a nutshell supported decision-making is. Now, it also is a simple written agreement. Some states have templates or written agreements that are ready and available, or there could be no agreement. For example, Maryland does not provide a form per se, a statutory form that can be used. Maryland right now says attorneys or others should create those forms. And even if there is no written agreement in Maryland, there can be an oral agreement. A person does not have to have a written agreement. So as we think about this, this is the scope of what SDM is. It's a formalization of authority for a supported decision maker to be recognized as such. Now that's an important thing. It's a subtle thing, but it's important. It's an alternative to adult guardianship, as many of you know, and it's a potential addition. It's a potential tool to be used in addition to financial powers of attorney and advance directives. And it's a tool in some states, not all states, it's a potential tool in guardianship. Some states allow for a guardian under guardianship, I should say, a person who is a ward under a guardianship to still have a supporting decision maker. And Maryland is one of those states that allows that. So that's something that we're not wrestling with really, but really getting ready to see where this really goes in Maryland about how courts are treating this in Maryland. We're going to actually look at the examples of that. And it's part of a big paradigm shift. As many of you who are educated on supported decision-making know, this is a mandate that's come down from the United Nations, mandate on human rights. And it's a recognition of a new paradigm shift where people, through the supported decision-making laws, are empowered with a new sense, as we see in the last bullet point here, a new self-determination, a new theoretical sense of self-determination. And our job, I think, is to figure this out. Our job is to work through the issues, try to find ways to make this less ambiguous. And as we get ready to get into the meat of the discussion here, I know some of you are dealing with this issue where you're seeing probably the same thing I'm seeing. You're seeing that certain people with disabilities will be able to appreciate the nature of supported decision-making, and we'll talk about this later. Certain people with disabilities are not able to appreciate the nature of supported decision-making or its benefits. Certain parents and supporters of persons, or I should say supports or family members of people with disabilities are able to appreciate this and they're excited about it, while others are skeptical. Others think that supported decision-making is a utopian idea that really doesn't have any practical use. So as you look at this issue, I think each of us has to look at our own state law. Each of us has to see what the tool, the purpose of how SDM, I should say, can be used as a tool. And we have to find a practical path forward of what it means for each one of us and each situation that we're dealing with. So as we get ready to move on now, that's going to be my goal here today. So I was very fortunate years ago to meet someone that many of you may know, a lady named Megan Rusiano, who's an attorney. She used to be a person who, she may very well still live in Maryland, but she was a person who worked for Disability Rights Maryland and now works, to my knowledge, for the ARC of the United States. And she has been one of the most leading advocates, if not the most leading advocate for supported decision-making. And I met Megan over many years ago at a presentation at a local ARC, and she was presenting on supported decision-making. And ironically, I was presenting on guardianship. And that's where I first got my feet wet, or I learned about some of the basic concepts of supported decision-making many years ago. And Megan has just done an amazing job, as many of you know, to promote and see supported decision-making succeed, not only in Maryland, but in other places. So Maryland follows the lead of several other states, including our neighbors here in Maryland, Delaware and the District of Columbia, as well as Texas, Indiana, Alaska, Wisconsin. Maria, again, was just telling me about Alabama, and many other states that have followed the path towards supported decision-making. And this fulfills a long overdue change in that approach, that paradigm shift from the traditional notion of guardianship to a new world of self-determination for those who can exercise their capacity, no matter what level that is, no matter whether it is a significant level of capacity or just a minimal level of capacity of self-determination, kind of rewriting the definition of what capacity and incapacity is. So again, it's a very broad topic to try to get our minds around, but a simple concept overall. And a brief history of supported decision-making, as someone like Megan Rusiano could articulate much better than I. Again, to my knowledge, this started in British Columbia, or at least Megan's experience with supported decision-making started in British Columbia, Canada, where it worked successfully. The United Nations mandate, we talked about many states that have adopted supported decision-making prior to Maryland. and prior to other states like Alabama. And again, this represents a departure from the old paradigm. This is difficult for lawyers and legislators to understand. I was just involved in a legal action the other day where I was talking to another lawyer who really clearly could not appreciate or could not really understand the difference between how someone could be under a guardianship and still be allowed to have a supporting decision maker. So I believe we are in a world of continuous education about this issue, and we have many years ahead of us of work to get this concept to where it should be. There's a fear of change. There's a fear of fraud and abuse. And rightly so in the world that we live in today. But thank goodness, at least in Maryland, and now I hear in Alabama, the legislature was able to move past, and many of the elder law and other attorneys were able to move past some of their concerns about this issue. So why is supported decision-making so needed in the world, so to speak? Well, there was no good alternative to guardianships versus a power of attorney document. And note, I know I'm talking in very simple fundamentals to many of you, but I will act as if you know nothing about this subject, and I'm going to try to approach it from that point of view. So we've got powers of attorney and advanced medical directives as the basis of someone's ability to exercise their capacity. We're going to look at that in more detail, and we're going to look at a flow chart. But there was really no alternative that was good other than what I might call settlement agreements or consent orders in guardianship that had to be crafted on an individual case basis by attorneys in guardianship. There was no alternative between the exercise of capacity, full capacity, with powers of attorney and advanced directives, and guardianship, at least in Maryland. And I'm sure in many states this was the case. So there was no formalized way for a person with disabilities to be supported. There is no annual review, at least in Maryland, of private guardianship. There was no clear way for alternatives to adult guardianship to be explored. And I can only share from the Maryland perspective that may not be different than your particular state. Courts apply the rules, were applying the rules, and may still continue to apply the rules differently in different counties and jurisdictions. So now with supported decision-making, we are going to have more of a uniform approach to all potential alternatives to guardianship. So this inconsistency is what I'm talking about here in the judicial application of existing law, old notions of traditional guardianship really being conceptually inequitable and no longer needed. And I'm going to go out on a limb here and say basically that this was a culture of paternalism. So this was a culture of minimizing risk, risk minimization, and that exactly hurts the potential of a person with disabilities. So what am I saying there? I'm saying that the idea was, the old paradigm was to protect, and that it was important to protect persons with disabilities because they could hurt themselves, they could be taken advantage of, they could be abused. Well, one of the notions of supported decision-making is that to be free, to be able to exercise capacity, means that one has to have the ability to take risks. So if we minimize risks, we are actually taking away the ability for a person to exercise capacity. So this culture of paternalism has now shifted to a culture of risk. And I think this is the concept that gives many parents, many people who are, supporting family members, it gives them pause, because the idea is, how dare our legislature give our loved one with disabilities the power to take risks and to expose themselves. And many of these people are vulnerable. So this concern that we are going from one extreme to another, at least in Maryland, is understandable, and the concern of parents and other family members. So this is why supported decision-making was needed. Is it perfect? No. And that's why we're going to continue to struggle through it to find its uses and its utility for the maximum number of people. Now, what were the tools that were available? Well, I mentioned a few of them already. Financial powers of attorney were the tools available. Advanced medical directives or health proxies were the tools available, where one can appoint an agent. And when we have an agent and that agent is able to act for us unencumbered, we don't have a need for adult guardianship. So I'm talking about the ability to exercise capacity and appoint agents for financial and agents for healthcare. Representative payee status is an alternative to guardianship. Joint ownership of financial assets, surrogate decision-making. In Maryland, we have surrogate decision-making where someone, a spouse or children and so forth, in an order of priority, have the ability to make healthcare decisions. We don't have surrogate decision-making on the financial side in Maryland, for example, and you're going to want to check this in your own state. But this is the ability to avoid guardianship, even if there is no advanced medical directive and no agent under the advanced medical directive. So the tools for dealing with disability had to do with all of these things. And also, of course, guardianship of the property. Many states would call this conservatorship, and guardianship of the person. And of course, I mentioned consent orders because here we have attorneys in guardianship proceedings. The guardianship is not going to go all the way to fruition. It's not going to result in a finding or an agreement or a judicial finding of incapacity. So there has to be a settlement. And that's what many lawyers were having to do and still may do in courts to settle guardianship cases where they don't go to the full extent of a guardianship by judicial decision. All right, so with that said, let's take a breath and just now look at what supported decision-making is not. So we've talked about what supported decision-making is in concept. We've talked about alternatives to guardianship, and we've talked about tools to deal with disability. Now let's talk about what supported decision-making is not. And why are we doing this? We're trying to just be laser focused on what it is. And hopefully for some of you, this will make it more clear. So supported decision-making is not a financial power of attorney. Remember, in a financial power of attorney, the person who is the principal is appointing an agent, and that agent acts according to the power and the timing that the principal has provided. And that financial power of attorney is a substitute for guardianship. Supported decision-making is not that, because supported decision-making does not allow someone to make decisions for the person. Supported decision is not a way for a third party to make a decision for the disabled person. I just said that, and that's a different way of saying it. Supported decision-making is not giving authority to the third person to do what they deem is appropriate. It's not giving authority to the supporter to do what they think in their discretion is appropriate. It is not a mechanism by which a person gives up their rights. Okay, so here in power of attorney world and advanced medical directive world, the person is exercising their rights to self-determination. In supported decision-making, they are in essence keeping their self-determination. They are not giving up any rights. Under a financial power of attorney, they're not giving up any rights. And a supported decision-making agreement is not adult guardianship. Although, as I mentioned earlier, in Maryland and in some other states, a person under guardianship can have a supporting decision maker. And in Maryland, as we're going to see in the legislation, if we have time to get to it, is the guardian cannot unreasonably say no. They cannot say no in an unreasonable way to the person under guardianship having a supporter. So what are the differences between supported decision-making and adult guardianship? So as Jeff and I like to say sometimes when we do joint presentations together, we're going to be intentionally redundant so that we can drive home certain things to you. So what is the difference between these things? Well, in adult guardianship, we have a removal of the person's rights in general. The person is giving up their rights to their property, the rights to their person. Now, some guardianship orders vary in this respect, but generally speaking, that person is giving up their rights. Their right to decide on their place of abode, their healthcare decisions, voting, unless that's specifically included in the guardianship provision. The person has no real legal choice. Now, have they given up all of their rights? Well, technically speaking, no. Even the person under guardianship has not given up all of their rights, but under the old paradigm, they have given up a substantial amount of their rights. Again, as I mentioned earlier, this is a paradigm of what I would call protectionism or paternalism, with no recognition of a person's rights to take risks, a fear of failure. Okay, so now let's say we are going to shift to a culture where we're going to give people more rights to fail. But continuing on this list, guardianship, there's no review of private guardianships, at least in Maryland. There's a review of public guardianships, but not of private guardianship. And as many of you have read and experienced, perhaps, there's an unspoken consensus of permanency. Guardianship is not supposed to be permanent, but I have reason to believe that up until just recently in Maryland, guardianship was considered largely to be permanent, and there was no real recognition among the judiciary of a person's right to prove that they no longer need a guardianship and have the guardianship removed. So this is kind of the beginning of understanding the difference between SDM, supported decision-making, and guardianship. Now with SDM, conversely, we have no removal of rights, no loss of rights, and we have the potential restoration of rights. Let's say someone is under guardianship and there's a petition to terminate the guardianship. Well, now, not only do we have a path forward, let's say in Maryland, of proving that based on 2 physician statements, this person no longer is incapacitated, does not need a guardianship, but now we have a path forward to say this person could, if it's appropriate, not be under guardianship and be able to be their own person with a supporting decision maker to help them make their own decisions. So again, this is a case-by-case basis, a situation. This is something that really causes a lot of questions by parents who want to know, hey, should I terminate the guardianship of my child? And again, surprisingly, many times I will recommend no, because that child is vulnerable. That child, even though they can have a supported decision maker and perhaps have the guardianship removed, perhaps it should not happen because of the vulnerability of the child. As opposed to guardianship, if we look at the next bullet point, this is a paradigm of individual risk, giving the person the right to fail, the right to be free, and to make mistakes. As Megan has told me several times, Megan Rusiano, we all make mistakes. We make mistakes every day. We take chances every day. We make decisions that maybe aren't the best for us every day. And that's what this is allowing people to do. Although I realize this is a very broad scope of reaction that we're talking about here to this subject. It can be an additional part of a guardianship. It can be an addition to a financial power of attorney. It can be an addition to an advanced medical directive. Now, let's talk about this financial powers of attorney and advanced directives versus supported decision-making. We talked about guardianship versus supported decision-making. Now let's talk about financial powers of attorney versus supported decision-making. So in the financial power of attorney and advanced directive world, the agent who has been appointed by the principal acts for the principal according to the powers provided. The principal says when the power becomes effective. The agent acts for the principal when the principal can no longer act for themselves. The agent has fiduciary responsibility, and that agency relationship can be terminated by the principal, and it should be, and it must be in many states, in writing. And power of attorney, advanced medical directive, is a substitute for guardianship of the property and the person, providing that the person has agents. So we never want to run out of agents, and we want our loved ones, we want our persons with disabilities who are friends to have more than one agent, ideally, so that they never run out of agents. Now, juxtapose that with supported decision-making. There is no agency relationship. So remember, in the power of attorney advanced directive world, there's an agency relationship, but there's no agency relationship here. The power remains in the person, the principal. The principal alone makes their own decisions with the help of a supporting decision maker. There is no authority for the supported decision maker to act on behalf of the agent The supporter does have accountability, at least under Maryland law, and I'm sure under your state law, depends on the jurisdiction. And the supporting decision maker's role can be changed or terminated, and this is recognized as a substitute for guardianship. All right, as we go past the halfway point of the presentation, I want to make sure that I'm on time. So now we're going to go into kind of a culmination of what we've discussed over the last 25 minutes or so. And I'm going to show you a chart. And I also want you to take a look at this first part of what I'm getting ready to show you. Let me go to the chart first. And as I thought through this whole idea, and how do I explain this to clients? How do I make sense of this to families? How do I make sense of this to people who want to learn about supported decision-making? I decided to really call this the self-determination continuum. We have the long-term care continuum, we have other continuums. Well, here, starting left to right, we have powers of attorney and advance directives. And in the middle, we have supported decision-making. And on the far right-hand side, we have guardianship. And in Maryland, you'll see that supported decision-making is possible even under guardianship. But now that you have a glance at this chart, let me go back to this narrative summary of the chart. So with powers of attorney over here, left to right, I'm the principal, I can make my own decisions. And if I can't make my own decisions, my agent will step into my shoes and make my decisions for me. What does that say? That says that I retain my right of self-determination. Now, if I go to the extreme opposite end on the bottom there, it says under guardianship, I generally cannot make my own decision, and I need the protection of a guardian. I may be a vulnerable person. I've been deemed to need the protection of a guardian. I may, in some states like Maryland, I may be able to have a supporting decision maker, even though I am a ward under guardianship. Now, in the middle, there's supporting decision making. I can and I will make my own decisions to whatever extent possible, no matter how much my capacity is or how little it is, theoretically, provided that I have the support to do so. So as you look through the presentation in your own time, I encourage you to come back to this self-determination continuum, where we see I'm retaining on the power of attorney side, I'm retaining my right of self-determination. I'm continuing to retain my right of self-determination in the middle there with supported decision-making. And only when I get over here to the right-hand side, where I'm looking at my screen, under guardianship, have I lost my right of self-determination, lost my legal rights, so to speak. But that can be, in certain states, modified to allow for a supporting decision maker. So theoretically, not only from the beginning, I really haven't lost all my legal rights, but technically I've lost my decision-making rights. But under supported decision-making, I can retain, theoretically, much more rights under guardianship. And this is what's so difficult for many lawyers to get their minds around. So I encourage you to focus on this continuum and to say to yourselves and to say to the person with disabilities, where do we fall on this continuum? Say it to parents. Where does your child, your loved one, fall on this continuum? And hopefully this will be a tool that will help you think through this issue more clearly. Again, I will say some people will appreciate supported decision-making, some people cannot. Some parents will support supported decision-making and some will not. We have to decide what supported decision-making means to us individually, and we have to decide as a society, are we willing to provide the support necessary, even for those who really can't appreciate the nature of supported decision-making, the people with disabilities who cannot appreciate it? Do we have a responsibility as a society to help them exercise as much capacity as possible, even when they don't necessarily understand it themselves, that they have these expanded rights? Okay. So I'm articulating things sometimes in advance and sometimes redundantly, as Jeff will remind me. So let's look at the problems and challenges here. As I just said, some persons with disabilities understand and appreciate their new expanded rights. of self-determination under supported decision-making. Some persons with disabilities do not understand it, will not understand it, and that's just the way that it will be. Some parents are enthusiastic about supported decision-making and its possibilities for their loved ones. Some parents are indifferent, and some parents do not understand the utility or the value of supported decision-making. Some people say, well, who will step in and be a supporter for my loved one with disabilities and maybe even do it without compensation? I mean, Steve, this is a utopian idea. I heard a certified elder law attorney at a very major national conference who has a special needs child. I heard this person articulate this very thing. And in her eyes, this is the reality of it. This is all very nice, but who's going to step in? So these are the challenges. And without public education on a vast scale, how will supporters know the extent of their responsibilities? I remember presenting at the Maryland Brain Injury Association conference a couple of years ago on this subject when supported decision-making was getting ready to be passed. And one of the big concerns among people who are potential supporters is what is their extent of their responsibility and their liability. So sometimes the laws such as the one in Maryland we're going to discuss briefly is so broad that sometimes it leaves people a little bit breathless to understand where their scope of responsibility is. How will the public be educated? That's something we have to ask ourselves. Now let's look at the Maryland legislation. Wherever you are today, whatever state that you reside in or practice in, I want you to juxtapose this with your legislation. I find that the Maryland legislation is easy to read. I'm just going to do some highlighting here for you so you can get a feel for what we are experiencing here in Maryland with what I believe is a very broad supported decision-making law. So let's look at the definitions. A supported decision-making agreement can be put in place with or without a written agreement. And that's pretty eye-opening. It is a series of relationships. It's not just one person. It can be more than one person. Some of you now, if I stopped right there, can start to imagine the anxiety of some parents who are concerned about what does this really mean and how broad it is. But it is to make, communicate, or effectuate the adult's own life decisions. That's what a supporter is supposed to do. So again, it's an arrangement with a supporter or supporters. And it describes this agreement, especially if it's written, it describes how the adult should use SDM to make their own decisions. It defines the rights of the adult and the rights of the supporter, responsibilities of the supporter. And again, a supporter is an individual selected by an adult to provide support in making, communicating, or effectuating the adult's own life decisions. One of the first examples someone ever said to me was, Steve, a person who would be deemed by others not to be able to express themselves too well, but as long as they could express even the smallest thing, they wanted to go to a ball game, they wanted to get a hot dog. And Jeff, by the way, the Orioles are playing much better, so that might be a reality here in Maryland. But if the person wanted to and could express that, their wishes should be respected. This is the concept of how broad the supported decision-making law is, the supported decision-making concept is. The purpose is to assist adults by obtaining support, again, in making, communicating, or effectuating decisions corresponding to what? The will, preference, and choices of the adult. Do you see where this is going? The person should be heard already. The person should already have these rights, but this law outlines in more detail that this person actually has these rights and they have the right to expect to be heard. To prevent the appointment of a substitute decision maker, including a guardian. The adult may use supported decision-making to increase their self-determination, prevent the need for a substitute decision maker or guardian, limit or terminate the use of a substitute decision maker. And all adults, this is important, all adults are presumed capable of making a supported decision maker agreement. This is to be construed liberally. Now, this literally is what the Maryland statute says. And for those of you who are interested in more details on this, I wrote an article, gosh, I guess about a year ago, and it's been very widely read, and not because of any particular magic that I did with the article, but I took liberal use of the Maryland statute to describe it. And I think that's one of the reasons that it's been so widely read. So if you'd like to see my article on the new Maryland supported decision-making law, Jeff and I are happy to send that to you if you could let us know or let Maria know. Now, let's look at some of the nuances. The manner of communication. The manner of communication of an adult is not a ground for determining that adult's capacity for making or changing or revoking an agreement, like a supported decision-making agreement. The supported decision-making agreement cannot be used as evidence of incapacity. It cannot restrict the adult from acting independently. And let's talk about the guardianship provisions, at least under the Maryland statute. A person under guardianship may enter into a supported decision-making agreement. The court may limit or remove guardianship due to the existence of a supported decision-making agreement, and a guardian cannot prevent it without good cause. In other words, they cannot unreasonably deny the person the right to have an agreement like this. So support is defined, I should say, as gathering information, understanding and interpreting information, weighing options, understanding consequences, the pros and cons of a decision, participating in conversations with third parties, and providing support to the adult in implementing the decision. I was fortunate to deal with a caregiver from a local state organization who was a house manager for an elderly lady I knew who was disabled. And I wish that we weren't constrained by confidentiality and so forth to really give this person credit, because she personified the items here that define support, as how she acted for this person and how she supported her throughout her life. So this is a very important definition here, the definition of support. The responsibilities of the supporter, in a nutshell, to support the will and preference of the adult. And this is important, without the insertion of the supporter's opinion about the reasonableness of the adult's wishes, preferences, or choices. And this is one of the things that this dear person did very well and was very talented to really do that for this person and enhance their decision-making, even though they were disabled. To act honestly, diligently, in good faith, as you would expect. To act within the scope of the agreement. Now, because the agreement can be oral, this is causing some heartburn with some parents. So what does that mean? How can a supporter act within the scope of an oral agreement? Well, we have to just rely on the statute. Maintain records about the supporter's actions and how the adult communicates and so forth. So this is a relationship of trust and confidence. Now, let's take the negative side. What can a supporter not do? What may they not do? Well, they may not make decisions for the adult. They may not exert undue influence on the adult. They may not coerce the adult. All of these things we would certainly hope that would not happen. They cannot obtain information about the adult without the adult's consent. They cannot enforce decisions made by the adult outside of the adult's presence unless they are authorized to do so. And of course, they cannot act outside of the authority of the agreement. Who cannot be a supporter? Well, a minor, a person who has a peace order against them, or a person who has been convicted of financial exploitation. Now, the resignation of a supporter must be given orally or provided in writing. I would always recommend it be in writing, and to all others named other named supporters or third parties. And the authority of the supporter, of course, ends on the supporter's incapacity, of course. Now, the requirements of a supported decision-making in Maryland, I'm not going to put you through too much about this, but here are just a few things. It must be documented, dated, and witnessed. Now, of course, this is the written form. We've developed a written agreement, and I know many other Maryland elder law attorneys have probably done the same. It must name at least one supporter and describe the decision-making assistance that this should be provided or can be provided to the adult. And it should describe how the supporter may work together if there's more than one, and describe any potential conflicts and how they could be mitigated. Continuing on there very briefly, it should document the adult's selected supporters. It should be approved by a court if there is a guardian under a supported decision-making, a supported decision-making agreement under a guardianship, and it must contain an attestation of the adult's independence. Now, the adult can revoke the agreement orally or in writing. Third parties can rely on it. Third parties may also decline to comply with SDM if they have actual knowledge of an invalidity of the agreement, an abrogation of the agreement, or coercion or undue influence. Third parties may be held liable for causing personal injury, recklessness, or intentional acts, failing to give effect to the adult's decisions, failing to provide information to the adult that would be necessary for an informed consent, or other actions inconsistent with the law. Now, as we start to move toward the end of the presentation, I've thrown a lot at you. Let's talk about how supported decision-making may benefit persons living with disabilities, or in this case, perhaps persons living with brain injury. Well, persons living with disabilities no longer are restricted or limited by their diminished capacity. So we have to understand that if nothing else, this is a conceptual expansion of human rights. The paradigm of risk should encourage the ideal of independence and the road to recovery. I know many of you are dealing with those with brain injuries that are on the road to recovery. The paradigm of risk should encourage this. Is the paradigm of risk appropriate for everyone? Probably not. But this is the concept we are teaching this afternoon. This is a new empowerment and recognition of the continued right of self-determination. Again, a new paradigm shift. It's a new way of legally articulating the role of a supporter, a new legal path forward. It's a psychological shift. It should not be limited or pigeonholed. I think if I may speak for Megan briefly, I think one of her concerns, at least in the past, has been we now have supported decision-making in many places, but we don't want to pigeonhole it. It should be something that is broadly interpreted and continued to be understood. The ideals of independence and right of self-determination are not diminished by a real need for guardianship. So my point is there that if you're living in a jurisdiction where there is a need for a guardianship, the loss of independence does not have to be complete. And hopefully your state allows for a supported decision-making agreement under a guardianship. And again, new protections from guardianship itself where it's appropriate. So before we get to the questions, if anybody has any, and Maria, fortunately, in the interest of time, we did get finished in time for some questions. If we want to engage in questions, I suggest that wherever you are and wherever your loved one may be, or if you're a provider, your families that are supporting their loved ones, I strongly recommend that they consult with a local attorney in your area that is an elder law attorney and understands the supported decision-making concept. This is assuming that you have supported decision-making in your state, that your families and that they complete an elder law questionnaire so that the person who's evaluating the needs of that family, that they have complete information. Your families and those that you support should understand and relax that there's nothing to fear. There is an attorney-client relationship. If they are consulting with an attorney, there's an attorney-client relationship that attaches from the beginning. They should bring the person's estate planning documents. If the person with disabilities has estate planning documents, they should consider other team members, such as an advisory team like CPAs or financial advisors, and they should prepare questions. Attorneys should embrace questions that can be answered and help achieve goals. And these families and individuals should be given time to think. Many of them, like you, are probably overwhelmed in taking care of people, and we all need the time to sit and think. And they should develop, depending on your state law, a supported decision-making agreement, and really get into the meat of your state law, which should not be complicated to understand. And if it is not understandable, that you get an interpretation of your state law from a local attorney that understands that particular aspect. So I thank everyone for letting me teach this last 50 minutes or 55 minutes or so of this workshop, for hanging in there with me and learning about supported decision-making. And Maria, I'm going to turn it back to you. It's been my privilege to present, and we'll see how you're wanting to wrap up the presentation and see if anyone has questions.
Outstanding. Thank you so much, Steve. What great basic information and so many things here to unpack. There are, as I know, experience every time you present on this topic, people who are very much in favor of this concept and people who have a lot of concerns. And you can see some of that reflected in the chat today. A couple of questions that I see. One in particular is related to what happens to someone with a disability when they make a decision that leads to their murder. There was a case apparently in South Carolina where that happened. Anything you would like to comment about that?
Yes, I think I'm not knowing the complete context of the question. I think this, and not having seen the chat because I'm presenting and wasn't focused on it, but I get the sense that this is, a tragedy, obviously, and maybe questions are being asked, I should say, that perhaps this person was given the right to fail, the right to take risks. I'm not sure what the facts and circumstances were. I would just say that this is what we're dealing with. This is the challenge of it. If I'm understanding anything about the question, the challenges of the traditional paradigm versus the shift in the paradigm, and to what extent is someone going to be making bad decisions where they should have been protected. Now, I don't know if this person had mental health issues. I'm not sure whether it was a brain injury situation. I'm not sure. These kinds of tragedies, I really don't have any comments on, except to say, I think this is the tension on that continuum of self-determination, and where does a person fall, and where does a person need protection versus they shouldn't have protection under a guardianship.
Yeah, thank you. Can you speak further about Maryland's recognition of the guardianship and or SDM instead of either or guardianship and other states' provisions? Was allowing the guardianship to also be in effect common with other states, or was this a compromise in terms of moving the legislation forward?
That's a great question. I don't know the back end of that question. I wasn't party to the discussions, although I did have a very small part in being a witness before the state legislature about this issue. I will say that, to my knowledge, states like Indiana have guardianship statutes that allow, or supported decision-making statutes that combine an ability under guardianship to have a supported decision maker. So Maryland, I believe, followed the example of a few other states that allow this. And I think, to be honest, went from zero to a full out, very broad law that leaves us breathless. And we are still seeing how courts are treating this. I'm looking at a few cases right now that I'm aware of where we have guardians, and the guardians are being challenged basically by higher functioning adults with disabilities who want to have a supported decision-making agreement under guardianship. And I think we're going to see the courts allow that, in my opinion, unless there is a very strong reason on the part of the guardian to deny that.
Great. We probably have time for one more question. This is interesting to me as well. Can you talk about tools for ascertaining a person's preference to choose supported decision-making? Where communication might be complicated, there seems to be a default to guardianship over that option, though that doesn't really determine the preference by the person.
Yeah, and my attempt to try to answer that question sensibly, I'll say most of the cases I'm seeing right now are guardians or parents that come in to discuss supported decision-making concepts. Sometimes the parents will bring in the person under guardianship, or the person potentially that they are thinking about obtaining guardianship for. I'm not getting a lot of meetings right now, although I'm seeing cases handled by other lawyers. I'm not getting a lot of cases where a person under guardianship has called us and asked us to move forward in an action to remove the guardianship. However, And I'll try to get to your question quickly. However, I believe those kinds of cases are coming in larger quantities as supported decision-making seeps into the consciousness of people. And as people under guardianship that are higher functioning, so to speak, will recognize that they have this ability to ask for a guardianship to be terminated. Tools, I guess, would be, I guess, all the normal capacity or incapacity tools. One, of course, is a great tool that's offered by the ABA. It's a brochure or pamphlet or booklet on ascertaining capacity. But of course, in the aspect of terminating a guardianship, at least in my view here in Maryland, we would have to show strong evidence by way of 2 physician statements that the person is deemed to have the capacity to make their own decisions. And where it would be close or borderline, I think it would require a hearing. And in the same way, let's say that a judge is interviewing a person who appears in court. Here, this person's right to be heard, of course, would not be waived because they're bringing the action to terminate the guardianship, and they would speak to the judge. And I think a strong case would be made if this is what we were doing and representing that disabled person under a guardianship, that we have to have 2 physician statements plus a very strong ability to name a supporting decision maker and an ability of this person to be able to exercise capacity and let the court make that decision. But I have reason to believe that if the person produced those 2 physician statements alone, that the court probably would have no choice but to terminate the guardianship.
Makes sense to me. We had several people ask about getting a copy of the article that you referenced, and we can follow up on that and post it later. And I would love to see the brochure that you're mentioning about ascertaining capacity. We could also share that as well, I hope.
Yes, ABA has that for sale as far as I know, but Jeff and I will let you know what that is. Many of you may or have already seen it, but it's an ABA tool on how to ascertain capacity or incapacity.
Outstanding. Thank you so much. This has been amazing. We are so happy that you were willing to share your expertise with us and some lively discussion in the chat for sure. We are at time, unfortunately, but I wanted to at least mention some other training events that we have coming up for the rest of the year. Please feel free to join us for any of these trainings or products or podcasts or anything that you see on our website. And most assuredly, we would love for you to join us at our annual event, which will be in Minneapolis in September, our State of the States conference. Don't forget to fill out your evaluations. And if you'd like a link for a certificate attendance, they will be in there following the completion of those evaluations. Any last comments that you guys would like to make before I close us out?
Oh, thank you, Maria. So I just want to say thank you to everyone. Thank you for all your questions and all your comments. And I would like to thank NASHIA for having me. And Maria, thank you so much for your kindness. And we are privileged to have presented. And I wish you well.
Thank you so much for joining us. We definitely appreciate all that you shared with us and your time. And to everyone else, thank you and have a great day.
Thank you.
Thank you, Maria.